Dictation 120 words per minute. British start. The other objection which has been raised is that the agreement dated 12 to 1986 required registration under the provisions of the Indian Registration Act. The unregistered agreement would not be admissible in evidence. Hence, it could not be acted upon. Yet another objection which has been raised is that the suit was filed beyond the period of limitation. In support of the first contention, a reference has been made to Section 107 of the Transfer of Property Act, according to which the parties had to execute a registered lease deed, but the same was never done. We find that the High Court has rightly dealt with the question while holding that the plaintiff had not filed the suit for enforcement of agreement of lease. It was a suit filed for damages for the breach of contract. It was not a suit for specific performance of the contract. A promise was definitely held out by the defendant to the appellant for occupying the premises for a period of 3 years at a given rate of rent. The premises were in fact constructed in accordance with the constructions and specification of the defendant. For raising the constructions, the plaintiff had raised loans from the bank. Everything happened in accordance with the terms of the contract, except that the period of tenancy was indirect before 3 years of taking over of the possession by the defendant. Para. In our view, the trial court and the High Court, Section 71 of the Evidence Act is in the nature of a safeguard to the mandatory provisions of Section 68 of the Evidence Act to meet a situation where it is not possible to prove the execution of the will by calling attesting witnesses. The section provides that if an attesting witness denies or does not recollect the execution of the will, its execution may be proved by other evidence. Aid of Section 71 can be taken only when the attesting witnesses who have been called deny or fail to recollect the execution of the document to prove it by other evidence. Section 71 has no application to a case where one attesting witness, who alone had been summoned, has failed to prove the execution of the will, and other attesting witnesses, though are available to prove the execution of the same for reasons best known, have not summoned before the court. It is clear from the language of Section 71 that if an attesting witness denies or does not recollect execution of the document, its execution may be proved by other evidence. However, in a case where an attesting witness fails to prove the due execution of will as required under clause in bracket C of Section 63 of the Successive Act, it cannot be said that the will is proved as per Section 68 of the Evidence Act. It cannot be said that if one attesting witness denies or does not recollect the execution of the document, execution of will can be proved by other evidence dispensing with the evidence of other attesting witnesses. Stop.